Amid the flurry of Supreme Court rulings late last month, the justices also handed down a decision on what seemed to be a rather technical question of law around federal habeas petitions, a fundamental right that protects against unlawful and indefinite imprisonment. But as John Yang reports, the decision has big consequences for federal prisoners trying to challenge their convictions.
Amna, the case involved a man who was convicted in 2000 of having guns despite being a felon, a violation of federal law. He was sentenced to more than 27 years in prison, but nearly 2 decades later, the Supreme Court changed the interpretation of the law used to convict him. Under the new interpretation, he would be innocent. And so on those grounds, he went to court to have his conviction thrown out. But in a 6-3 decision that fell along ideological lines, the court said he couldn't appeal because he'd already challenged his conviction once before. Daniel Medwed is a professor at Northeastern University Law School and the author of Barred, Why the Innocent Can't Get Out of Prison. Mr. Medwed, what does this do for people like Mr. Jones in this case, people like him who want to have their convictions reviewed?
I think, as Justice Jackson said in her dissent, in a sense, this slams the door on people trying to raise claims of legal innocence, that the evidence can prove their guilt beyond a reasonable doubt after they've already filed one of their federal habeas petitions. This relates to federal habeas corpus, which is one of the greatest, potentially greatest post-conviction remedies we have in our country, but the Supreme Court has gradually whittled away at it as a tool for justice.
You mentioned Justice Jackson, another line in her dissent. She called trying to get a review, an appeal in the federal court, aimless and chaotic exercise in futility, artificial barriers, arbitrary dead ends, and traps for the unwary. How did we get here?
We got here over a series of twists and turns that were charted both by the Supreme Court and by Congress. There was a 1993 case called Herrera versus Collins, in which the Supreme Court said a claim of actual innocence by itself won't be recognized in one of these federal habeas corpus petitions. And then in 1996, Congress changed the law governing these federal habeas corpus procedures to make it very, very difficult to get into court. There are strict statutes of limitations, restrictions on when you could file second or successive habeas petitions, and other onerous procedural barriers. So I think this case, Jones versus Hendricks, is part of a multi-decade trend toward narrowing the federal habeas corpus remedy.
Is this something that the court is doing, or were the laws written to be hard for prisoners to get out of prison?
So if I were to allocate blame, I think it could go both to the court and to Congress, but mainly it lies at the feet of Congress.
They also, in this decision, actually Clarence Thomas, who wrote the majority decision, said that the Congress has chosen finality over error correction. What do you think of that?
Well, I think it's an interesting issue. So on the one hand, finality is often highlighted as a variable or as a factor in favor of curtailing post-conviction remedies. The idea is that at some point litigation should be final, or else victims won't have closure and the litigation system won't have the capacity to absorb new cases. But on the other hand, I think that finality is often a fallacy. What good is finality if, in fact, there is an underlying question of legal or factual innocence? That is a problem. I think accuracy is more important than finality, and sometimes that means we should take a closer look, maybe a second look, at a meritorious claim.
Talk about the people who are wrongly convicted, who are innocent and can prove their innocence. I think we all have the image from movies or television that someone rushes into the courtroom and says this man is innocent and he's released. But why is it so hard to correct a wrongful conviction?
A wonderful and important question. So a couple thoughts. First of all, there's a misimpression that biological evidence, scientific evidence, is available in all these cases. And if you can just find it and test it after your conviction, voila, the prison gates will open. That's not true. Biological evidence suitable, for instance, for DNA testing, is estimated to be available in only 10 to 20% of criminal cases to begin with. And that assumes that it's retrieved at the crime scene and adequately stored. Second, even without scientific evidence. It's incredibly hard to reverse a conviction because after a conviction, the presumption of innocence disappears, a presumption of guilt takes hold, and all of the procedures are stacked in favor of reinforcing and supporting that finding of guilt. It is so hard not only to find new evidence, but once you've found it, you have to overcome an array of procedural obstacles just to get into court.
Daniel Medwed from the Northeastern University School of Law, thank you very much.
Thank you so much, John.